I recently received a call regarding the amount of times that buyer is able to inspect the home prior to closing. In paragraph 7A of the 1-to-4 family contract, it states that seller shall permit buyer and buyer's agents to access the property at reasonable times. Buyer may have the property inspected by inspectors selected by buyer and licensed by TREC, or otherwise permitted by law to make inspections. When the agent called me to give me the scenario regarding inspections, she said that the buyer was wanting to do a full, brand new inspection the day before closing and wanted to know if that was reasonable and whether or not that was the intent of paragraph 7A of the contract. She believed that the buyers were trying to get out the day before closing. The seller agreed to a final walkthrough by the buyer, but wanted to know more specifically if the seller had to allow a full, brand new inspection. I was not able to give her a specific yes or no as to the inspection being reasonable. I told her that it depends on the situation as to what the court would rule when the question of reasonableness comes up. The seller would argue that one day before closing is not reasonable, but others may argue it is reasonable to conduct a re-inspection close to closing. After all, you don't drive a new car off the lot until you do a walk around. The contract does not specify what reasonable is. After hearing seller's frustration, I suggested it may actually be in the seller's best interest to allow that inspection before closing to prevent a claim by the buyer against seller for fraud. Fraud is 1, misrepresentation by omission or commission by someone who 2, knows or should have known of the defect, and 3, the other party relied on that misrepresentation that 4, caused damages. Sellers provide a seller's disclosure notice to buyer prior to closing and ideally prior to executing a contract. The seller's disclosure notice is a notice of defects that the seller knows or should know exist on the property. When a buyer gets an inspection done, the buyer no longer only relies on the seller's disclosure notice to make decisions, which potentially eliminates one crucial element of the fraud claim. Buyer cannot say that they relied on the seller's disclosure notice when an inspection showed a defect that the buyer had to pay to fix after closing. Lastly, after the option period, if buyer has a re-inspection, buyer doesn't have much leverage to ask the seller to make additional repairs because he has no right to terminate the contract if seller refuses. Sure, the buyer can send an amendment requesting repairs at any time, and the seller can accept or reject it. That is negotiable. Remember, as always, we want to be your trusted resource for results. Please come see us at the closing table.